Hello, my name is John White. I'm special counsel with Harness IP, and I've been a patent attorney in the patent space for about 40 years at this point. Most of that, though, I have spent teaching others how to do what a patent attorney or a patent agent does. Most people in the profession know me by virtue of me having taught them how to take this thing called the patent bar exam. By now, I've taught about 38,000 people, which is almost 3 out of 4 people who now call themselves registered to practice here in the United States. I am at Harness IP, where I work as an expert witness and I help with business development. And as a part of that, we have created something called Harness Academy. The Harness IP Academy is intended for anybody who would like to raise their level of understanding with respect to any topic in intellectual property. The courses are prepared for those who don't have a working knowledge, for example, scientists, engineers, and staff at a given enterprise, but also we have courses for those who work in patents and intellectual property every day. And many of those courses are qualified for continuing legal education because many of the people who might watch them need those hours, and so we can provide that. These courses can be provided on a taped basis. That is, they're available anytime anybody would like to look at them for free. But also, if you'd like me to deliver something along the lines of a special request, I can put that together and deliver it in a live format, depending on what your requests are. Some of the more recent ones that I've done on special request have been related to cases that people thought were very interesting and may change things with respect to how you prepare applications going forward. One was Sonos versus Google. This is a district court case, and it had to do with the prospect of prosecution laches showing up. I also did a program on Amgen versus Sanofi because this seemed to change what was necessary for purposes of underlying disclosure under 112 to support later claims. And so these are done by special request. I prepare them generally for the firm, which I present about every quarter. Clients are invited to those presentations if they'd like to be, but they can also be presented live in a live format at the client or also live through Zoom or some other format that suits them. But another recent one that I did had to do with statutory reform. And this is all coming upon us, as they say. And this is something that you should prepare for ahead of time, especially with respect to the Patent Eligibility Restoration Act. It's been introduced again, as has the Prevail Act. That has to do with modifications to the PTAB. But the modifications to statutory eligibility means if you plan to try to get patents on computer implemented methods, now's the time to be filing those applications, because by the time examination occurs, the law will likely have changed. So these are the sorts of programs that I can do. I can do them with or without slides, as the case may be, and I'm happy to do them for you. I look forward to seeing you at a program delivered through Harness IP Academy. Thanks.